Yes.
I wanted to mention that an original side public interest litigation, it concerns the requirement of Judges Ghat. Lordship had been, concerns the renovation of Judges Ghat. Lordships have been pleased to hear this matter for some time.
That is some arch was being
yes, yes, that matter. Now, that 8 days of work are left. We're almost complete, but the extension is required from the court. We have filed an application. It's been with item number 33 in the monthly list. If some preference,
it will come on Wednesday.
Yes, any day. Yes,
Wednesday.
Yes, grateful.
Lordship, may I plead for my lord's kind leave to mention one urgent matter, Lordship. This matter was heard by your Lordship on 7th of April, that is on Monday. Lordship may humbly recall, this is that matter that the appellant's son, who was a doctor who had died in a suspicious circumstances on a road accident, Lordship, and there was and the appellants had prayed for transfer of investigation.
We have passed some interim direction.
Yes, Lordship, you have passed the order, Lordship, and admitted, Lordship, the one simple correction that needs to be incorporated, Lordship. Instead of Central Investigation Department, it should be Criminal Investigation Department, Bhavani Bhavan, Alipur. Lordship, anytime Lordship keeps this matter next week to under the heading to be mentioned.
Today itself.
Lordship, grateful, Lordship. Grateful.
But you just inform.
I have mentioned upon notice, Lordship.
Okay. Today's list, and you can make the correction. Instead of Central Investigation Department, it should be Crime Investigation. Criminal Investigation Department. Yes.
My lord, may I kindly be allowed to mention a matter for inclusion of my name as a respondent, Lordship? I had given my list. Lordship, it
Let's say original side.
Original side, Lordship.
Original side.
Yes, Lordship.
Yes, Anjan. Show it as day's list and include. Yes, please call.
Appellate side.
Millard, may I beseech your lordship for mentioning for upgradation, Millard. WPEP 293 of 2024, Millard. For upgradation, Millard, it has been appearing as item number 158 on yesterday's list. Millard, Can 8 has been filed, Millard. The hearing is yet due, Millard. May it be upgraded.
Can 8 alone.
Can 8, Millard.
Yes.
Yes. Item 1.
Millard, I appear for the writ
I'm
petition.
obliged.
Now, my writ petition has been dismissed by the learned single judge without going into the merit. But I participated in a tender for construction and maintenance of road. There were total 29 for items tender was issued. I participated with item number 26 and 28. The tender, my technical bid has been rejected by an authority which is not the authority under the tender, on the ground that I have submitted improper machinery and manpower. I have annexed documents in the writ petition that all the documents was there or submitted. The learned single judge dismissed the writ petition because I did not write to the authorities.
But the learned judge says in terms of clause 22.
I'll show that, whether that is mandatory, whether that time was expired. Before that, I approached the they themselves have violated. But I'll very quickly take you.
Now, have you implemented the successful?
Yes, they intervened. I have implemented them. The Can 1 is the additional party. The work has not started. Even agreement has not been executed. It cannot start. I'll show from the agreement because as per clause 30,
it's a road construction.
May I just tell you? As per clause 30, they have to submit the bank guarantee within 10 days from the work order issued. The work order has been issued as per the learned single judge on the day when the order is passed. That was on.
That you come to it later. You please show on what ground your technical.
Yes, I'm so grateful to Lordship.
411. Page 411.
May I address your Lordship? I am for the appellant. May I address your Lordship? 411. Can 2, page 411. Now kindly see, it is in the box, SK Construction, engineering not qualified due to improper technical manpower and insufficient machinery document. My lords, kindly got that? Not 411 inside the box.
Due to improper technical manpower and insufficient machinery document.
These are the two. I will take your lordship to the document just 1 minute after this. Kindly look at the top of the document. This minute was prepared. 30th minute of the meeting, Department of Tender Committee held in the chamber of Devasis Biswas, OSD ex officio Chief Engineer, P and RD Department, Government of West Bengal. Malaras Kali got that. Now kindly come to serial number 11. Mr. Miraj Hossain, SE, Sub Assistant Engineer, RRNMU, Malda Circle, P&D, joined virtually present, and he is an invite member. But this gentleman has issued the tender. In terms of the tender, he is the one who has to decide who is technically qualified. He is an invitee member in the committee, and someone else who is superior to him has decided whether technically qualified or not. I'll take your loss of that. But kindly come to the technical qualification requirement criteria. But kindly.
Before that, you
Yes,
show
madam.
the relevant clause.
Yes, yes. I'm
How
so
the
grateful. Yes,
evaluation, who
yes,
has to
not
do the evaluation?
page 87. Page 87. But who will do the evaluation? For that, I need to show you lordship 2 more pages. Before page 87, I need to show you lordship page 43 and my lord page 76. Take page 43 first.
Yes.
See, my lord, who is issuing the tender? The superintending engineer, RR NMU, Malda Circle, West Bengal, State Rural Development Agencies, White Swanso for construction and upgradation of Pradhan Mantri Gram Sadak Yojana following for maintenance for 5 years. Page 43. He is the tender issuing authority. Now kindly come to page 76. Instructions to bidder, clause 1.1. The employer, as defined in the appendix of ITB, invites the bid. Now, employer is defined in ITB. ITB, you also will get me at
87.
page 87. দাদা আমি বলছি তো
ও আচ্ছা আচ্ছা সরি
আমি বলছি একটু ওয়েট করো পেজ 87 22.1 sorry
94
94
page 94 is the
this is what happens if someone interrupts.
Ajay, sorry
But kindly come to page 94. 94.1 page 94 clause 1.1. The employer is the superintending engineer, page 94. My lords, kindly got that? So he is to evaluate. Now kindly come to the clause of evaluation. How is to be evaluated? Page 87 is that clause. The employer, if your lordship has page 87, 22.1, the employer inviting the bid or his authorized representative will open the bid online, and this could be viewed by the bidder also online in the event the specified date for opening the bid being declared as holiday. For the employer, the bid will be opened on so and so. Then not kindly take 22.3. All bid cases, in all cases, the amount of bid security, cost of bid document, the validity of the bid shall be scrutinized. Thereafter, the bidders' names and such other details of as the employer may consider appropriate will be notified in part 1, so and so. Then 22.4, the employer will also prepare a minute of the bid opening, including the information disclosed in accordance with 22.3. So he is to prepare a minute, not become an invitee in the office of some superior who will decide the minute. It has been passed on the dictate of the superior officer. Then we will kindly see 22.6, under which the writ petition has been disposed of. The result of evaluation of part 1 of the bid shall be made public on e-procurement system, following which there will be a period of 5 working days, during which any bidder may submit complaint, which shall be considered for resolution before opening part 2. So my fault is, I approached the writ court within 5 days. They had the information. After receiving the writ, they opened the financial bid within 5 days. The single judge says, since I did not
Avail this remedy.
avail this, I cannot maintain the writ petition. Not which subject to correction, perhaps not is not the correct law. But kindly take one more page, not page 418. But I have a better copy for your lordship. Not kindly take this 418. But কোটা দুটো তো দাদা তুমি একটা নাও
না তো 10 টাকা
ও
এটা রাখা টাকা এটা হলো 1481 এটা 147
লর্ডশিপের দুটো করে কপি
দুটো
লাগবে
করে কপি দেওয়া আছে
হ্যাঁ এটা একটা সেট তো just to show your lordship the time আমাকে দে not kindly see এটা তোমারই document not kindly see at the top first box not the second box technical bid opening summary Malaras kindly got that this is 418 I'm giving you a better copy
480 is
418 418 I have just handed over a better copy Lord it may not be very legible see the second box from the top the technical bid opening summary technical bid was opened on 21st March at 4:54 p.m. Malaras kindly got that then kindly see technical evaluation summary technical bid was evaluated on 21st March 7:30 p.m. updated Malaras kindly got that Then kindly see the opening of financial bid summary. Next column, 27 March, 5:30 p.m. 22nd was a Friday. They opened the technical bid in the evening. So Saturday, Sunday is a holiday. They should have waited till 28 in terms of their own clause 22.6. They opened the financial bid on the 4th day. So if I have not written to him, that's his ground. He himself has violated that clause. Now to show me Lord, what is the technical requirement of the tender. But kindly take page
94.
page 94.
So like 98.
But page 95 kindly comes. This is a project under category B. Admittedly, if they dispute, I shall show. What is the machinery that is required? Page category B kindly sees. Machinery required, excavator come loader. The project is between 5 to 15 crore one. Lord, I have prepared a chart for your lordships on the various pages. What are the machineries that is available to us? That I have prepared a chart, which is more than that, but I have checked up. And the next clause which requires is, kindly see just the page I have handed over to your lordship. See whatever is required and what we have submitted, your lordship will find it. The equipment just see, Lord, excavator come loader required is one with existing
Most
five.
of them, according to you, is in excess of their.
Is in excess. Then the second requirement is page 98. The manpower. The documents annexed. I'm just giving a summary copy to your lordships. Just have a look at it. Whatever is the required number, I have supplied, I have given the document. They did not consider it. Someone else opened the technical bid. But I have challenged it on two grounds. Not the entire exercise is arbitrary. Firstly, because the available documents has not been considered is perverse. Second, the person who is not authorized, he has taken the decision or the decision has been taken at the dictate of someone else, superior officer. It was the superintending engineer who should have not chaired the meeting, who should have prepared the minute. Thirdly, they themselves have not adhered to their own time schedule. So, Lord, and fourth thing, I may not have written to the particular person. I approached your lordship's court on 26th of March. Within 3 days, the writ petition was served on them. Despite having that, they knew that what is the complaint in the writ petition. They proceeded with the opening of the financial bid. Before the learned single judge, an approach was made that the work order has been issued. And now today, there is an attempt to impress upon a lordship that work has started, which is palpably false. I'll show you lordships. Kindly take page 89 once.
We'll come to it later.
It
That
cannot
is-
start. It cannot start.
Yes, sir.
Lordship, my lord, 4 challenges mainly. Firstly, 3 challenges. I have manpower, but I have been denied the chance. I have equipment. Second is I have equipment, not considered. Thirdly, the decision-making authority that is without jurisdiction. These are 3 challenges. And 4th challenges come on the basis of the my lord observation made by the honorable single judge regarding recourse to clause 22.6. Firstly, let us come to first clause 22.6, my lord, page 87, my lord. Lordship, firstly, my lord, kindly see the nature of the work. My learned friends already referred to, my lord. Kindly comes to, my lord, page, my lord, 43. Nature of work. Nature of work is, my lord, infrastructural work. Page 43, my lord. The superintendent engineer, so-and-so, Malda, so-and-so, agency invites the percentage rate bids, electronic tendering for construction, upgradation of roads under Pradhan Mantri Gram Sadak Yojana. Now, my lord, kindly see what has he applied for? He applied for, there are so many these items he applied for. Kindly comes to me lord page 49. He applied for serial number 26 for upgradation of this road and serial number 28. No quarrel on the issue. So he submitted bid for these 2 items, lordship. So scheme is Pradhan Mantri Awas Yojana, this Sadak Yojana infrastructure. Without jurisdiction, first point. In para 10, he says, my lord, employer. My learned friend has showed the definition employer.
Page 94.
94. Employer is superintendent engineer. He should open. Yes, he has opened. But since this is a scheme under Pradhan Mantri Sadak Yojana, therefore the memo says it has to go before the tender committee of the department concerned. Kindly seize, my lord. At a copy diye do Shrijip ke. May I take your lordship, my lord, to page 12 of the bunch of document. Page 12, kindly seize, my lord. Tender committee in supersession of so and so. Previous orders also for all previous orders department engineering work for PMGSY, RIDF and other engineering related works executed from headquarters by department so and so following members. The committee can co-opt so and so. Kindly comes to me, lord. The second every Tuesday for finalizing tenders or framing rules and regulations for tenders. So since this work is PMGSY, therefore comes the decision from this tender committee at page 411. First answer, respectful answer to the query of my learned friend. Second, 22.6, my lord, page 87, my lord, of the my lord, stay application. What does it say, my lord? It says, my lord, kindly 22, result of evaluation of part 1. What is part 1? Part 1, lordship will see, my lord, page 63. Kindly, my lord, may I travel your lordship with page 63. Part 1 is technical beat part. Page 63, kindly see, part 1 is technical beat part. So his technical beat has been rejected. At that stage, he comes. So part 1, what does it say? Result of evaluation of part 1 of the bid shall be made public on e-procurement systems, following which there will be a period of 5 working days, during which any bidder may submit complaint, which shall be considered for resolution before opening part 2 of the bid. So, my lord, may I respectfully invite you, lordship, the first page, my lord, of the report, of the instruction. Kindly seize, my lord, date of publication technical bid was 21st March 2025. Financial bid opening 28 March 2025. Uploading of financial bid, that is in the public domain, comes on 2nd April 2025. 5 working day. 21st it was opened. 22nd and 23rd were holidays. Lordship, 21st, 22nd and 23rd were Saturdays and Sundays. 5 days. Yes, my learned friends, 5 days comes to 28. 5 working days comes to 20 March 2025. But it comes in the public domain. When? On 2nd April 2020. Bid opening takes place as lordship, technical bid. We open, evaluation, then comes on the e-portal. When it comes to the e-portal, that amounts to opening because it comes to the public domain. So financial bid opened, seen, it goes to e-portal in public domain on 2nd April 2025. Assuming we're not admitting that I'm wrong, he comes to court on 26th March 2025. The jurat of the petition says. So, Miller, my 2 respectful submissions. Firstly, Miller, on this, he has not taken his chance to prefer representation of.
No, according to you, this 5-day period will commence from?
On and from the day when it was uploaded on the portal in the public domain. That is 2nd April 2020 up to. Oh, comments. Comments will be from 21st March 2025. No, sorry. 21st March is Friday. Next comes Saturday, Sunday. So 5 working days. So it will start from, my lord, 24th March. Yes. 24th March. 24, 25, 26, 27, 28. 5 working days completes. But in the e-portal, in the public domain, the financial bid comes on 2nd April 2025. Lordship, assuming that yes, he did not, he comes to court on 26th March. 28 was the last date, 5 working days. He comes straight to Honorable High Court on 26th March.
Without exhausting that.
So relinquishment of his right given under clause 22.6, relinquishment is akin to waiver. Lordship, Now, my lord, his next challenge is, I had manpower, I have been given a raw deal. Clause 4.4, capital B, small b, Roman 2, kindly lordship comes to my lord. Page 30 of the writ petition. Page 30 of the stay application. He takes one point in petition, in writ petition, that I complied with, kindly comes to page 98 now, lordship. 98. 4.4b, small b, Roman, lordship got it, page 98 of the need document of the stay application.
Yes.
This is manpower needed. What does it say? The tender document. A, degree holder in civil engineering, 1, or diploma. B is diploma holder, 2. C is supervisor, 2. Lordship, may I respectfully invite your lordship to averment in para 5 of the writ petition. My lord, page 30, my lord. Petitioner states that in terms of clause 4.4b2, the required technical personnel are 111 so and so. Whereas the document submitted by the petitioner while dealing of the tender, it is apparent the petitioner have employed 3 technical personnel, namely, kindly note down the names: Himanshu Hajira, Shupriyo Mukherjee, Kamal Asif, who has degree in civil engineering, having experience more than 3 years. Furthermore, the petitioner had 2 technical personnel, namely Topon Kumar Das and Jayanti Sinha, who has diploma in civil engineering in the so-and-so, and Reshma Sultana as so-and-so. Topon Kumar Das. Topon Kumar Das, kindly take this note. Lordship, please. He has uploaded the documents and he himself has also annexed, my lord, to this particular stay application, my lord. May I travel your lordship, my lord, to page, my lord, 211 of the stay application. What has he uploaded regarding his diploma part, diploma technical engineer? His uploading of documents starts from page 161. Relevant is Shopon Kumar. It is to Shopon Kumar Das, never. It is not Topon Kumar Das. And who is Shopon Kumar Das, my lord? Kindly comes to my document, lordship. What does he say? Kindly sees. My lord, page, my lord, 1/4 of my bunch of documents, lordship. I have respectfully handed over to your lordships. So it is not Topon as mentioned in paragraph 5 of the report, it is Shopon. What does Shopon say? Kindly sees. To whom it may concern, where is that?
No, page
Sorry,
14 and
lordship. Sorry, lordship.
same document, 14 and 211.
Sorry, lordship. Lordship, page 6, my lord. Sorry,
Page
my lord. Page 6. What does Shopon say? This is to be certified that I, Shopon Kumar Das, am a permanent staff of PNR. He's a departmental staff. I have been working in the post of Nirman Shayak since 2008. From a faithful source, I came to know that my provisional pass certificate from Sri Ramakrishna Shilpa Vidyapith is being used in shake construction engineering without any concern, which is dangerous offense. I declared that I did not involve directly or indirectly with this type of work in any way. Even I did not know how my certificate is being used. This is for the kind information of this. This is what he has done. My lord, he has annexed his certificates also before your lordships. That will appear, my lord, at page, my lord, 213. If that be so, my lord, kindly comes to, my lord, page 80. So he, in para 5, he says Topon. It is not Topon, it is Shopon. What is Shopon? Shopon is a PRD department employee. What does he give the declaration? To whom it may concern, lordship, I have seen it shown. What does the tender document say? Kindly comes to, my lord, page 80. Clause 4.7, my lord, kindly sees, even though the bidders meet the above qualifying criteria, they are subject to the disqualified. They are subject to be disqualified if they have clause 1 is applicable, I'm relying on, made misleading or false representations in the form, statements, affidavits, and attachments submitted to them. So he has shown the manpower which is misleading, manipulate the manpower. Now next challenge ground is 4.4b1. That is, my lord, page 94 of the bid document.
95.
94. 4.4b, small b, Rome 1 comes to page 94. These are the equipments necessary. Whereas is segregated from, I do not know that I am this category B is applicable to me and category A is not applicable. I do not know, lordship. Whatever. Regarding equipments, 4.4b, answer, my lord, kindly seize, my lord. Answer to that is, my lord, may I respectfully invite your lordship, my lord, to my lord, the fourth paragraph of my report. He is awarded already 3 numbers of works he's carrying on with the machineries. And 1 he has got at Purbo Bardhaman also. I have annexed those documents. Kindly see page 7 of my report.
So he is an existing contract.
Already carrying on his works. That existing machinery he's trying to showing here and trying to get this contract also. At page 7, he is working. 9 working. Page 9 kindly see is working. Page 10 were 3 in Murshidabad. And 11 is in Bardhaman also. He has got 1. Not yet started, got 1. So that is the reason, Mizot. He has written this instructing authority. He's the tender inviting authority. That hence he has not the sufficient message to execute the work and so on. And the update as on date. Work order, my lord, has already been issued. Pursuant thereto, my lord, kindly comes to me the last paragraph of the report. Box cutting, subgrade rolling, picking up bituminous layer, and WPing works are in progress, my lord. To demonstrate this, my lord, the authorities have annexed, my lord, some of the photographs starting from page 38, my lord, to 41. Kindly seize. This work has started because before the onset of monsoon, it's a Pradhan Mantri Sadak infrastructural. So this is the update of the matter. 1 judgment, 4 paragraphs. May I have to rely on lordship?
Pardon?
1 judgment, 4 paragraphs. Lordship. My lord, 2022 में NG project judgment, lordship. 2022 volume 6 SCC 127.
127 SCC.
My lord, the issue was infrastructure. Para 3, my lord, may I respectfully invite your lordships to Para 3. Road Construction Department of Jharkhand invited tenders on so and so for reconstruction. That was the issue before the Honorable Supreme Court. My lord, kindly skip to, my lord, paragraph, my lord, 13. 13, my lord, placitum C, D, and E, lordship. I will not read out. Kindly read out, lordship. I am leaving it to your lordships, my lord. Placitum C, D, E, F, and G, lordship.
Yes.
And my lord, again, interpretation. One of the grounds in the memo appeal, he says that assuming that I was supposed to approach the authority, what difference would have been made from Caesar to Caesar's wife? There was pre-bid meeting held. You did not attend. You could have raised that issue that you have given a 22 and 22.6 clause to approach you once the technical bid is opened. It is from Caesar to Caesar's wife. Will not make any different result if I approach you. Did not attend the pre-bid meeting. My lord, para 13, my lord. Para 15, my lord. Placitum ABCD.
Yes.
Para 19 takes care of specific relief fact that new clause regarding refusal of injunction if it is infrastructural project. Para 19, my lord. Section 41 HA, it has taken note of that regarding infrastructural development, we should not. Milord, para 22. Lordship, para 20, sorry, para 21. Para 21. Para 23, placitum's GH only. Para 23, placitum GH. Lordship, for your Lordship, paragraph 26 and 27, kindly see what does it say, Lordship? Para 27. Lordship's duty has been cast on your Lordships.
Yes.
So, these are my submission.
Yes, sir.
Read that.
But only reply on 2 points, my lord. My lord, kindly take page 12 of the bunch handed over by my lord senior friend, my lord. Who, my lord, in response to the point of jurisdiction, he has shown this to your lordships.
Hmm.
Lord, kindly see the date. This is 29 July 2022. And this tender was issued, my lord, on 6th of January 2025. My lord, the tender document doesn't say that if you also kindly take page page 87 once, the clause of evaluation, it doesn't say that it will be done through a committee. It says employer 22.4, employer will prepare a minute. It is the employer who is to do it. Lord, whether there is a departmental notification, Lord, kindly recollect, Lord Amarnath Dayaram Setti, the tender committee also, the tender issuing authority also shall have to be abide by the clauses of the tender once it is finalized. There cannot be a change of rule when the game has started. Lord, 22.4 says, employer will also prepare a minute of the bid opening, including information disclosed. So it is the employer who has to do it. And if we see 411, he is an invitee member of a committee which has taken the decision. Second, see page 12 of the document. It says that in compliance with the finance department memo number so-and-so and supervision of previous orders, not about future order, departmental tender committee engineering work so-and-so and other engineering and related works executed from headquarter. These will apply to work which is executed from headquarter. Not subject to correction by my Latin friend, Lord. I may be wrong. Perhaps this is not to be executed from the headquarters. These are zonal tenders issued by the authority. Secondly, when you have yourself says in the tender document that the employer will take a decision, employer may take a decision, then may send it for approval to a committee. But the committee cannot take a decision instead of the employer. This is one. Second, Lord, with regard to machineries, I'll come to the manpower, which is the most difficult part, Lord, a little later on. Kindly take the machinery portion. My senior friend has said, I have got 3 tenders. So there is a presumption that I am using those machineries here. On the basis of that presumption, my tender has been rejected. He has not produced any document that same machinery.
Why did your client not participate in the pre-bid meeting?
My lord,
Why did he not participate in the pre-bid meeting?
Lord, that instruction I don't have. That point was not even taken. Lord, pre-bid meeting, I would have, Lord, my learned senior friend says, if I had participated in the pre-bid meeting, I would have asked a question, what is the clarification regarding 22.6? But today the issue is whether 22.6 is a mandatory provision. If I do not adhere to that, then my writ petition will fail. Lord, my writ petition has reached them before 5 days.
That
They
you
could
have
have-
said, you have
That
noted.
would have gone into that. Lord, in other way, I'm trying to establish my case that they had the information of the complaints that I have made. They could have said, yes, this is the reason you are rejected. I would not have placed my writ petition. But for that, I did not approach them. The perversity will prevail. The illegality will prevail. Perhaps that is not the law. Secondly, Lord, the machineries they are saying, I may have got 10 number of tenders, I may not get even one. Does that mean that all the machineries I am using in the 10 tenders, is it possible that I will pick up those machineries from there and bring it here, work in the day, go to the night and work there? So their contention is I have 3 tenders, I should not get one more. Because I am got 3 tenders, I might use my machineries there, here. Lord, that is, Lord, I think a perverse conclusion. With regard to the manpower, Lord, which is, I believe, which is a very, Lord, valid point raised by them. Lord, that instructions I do not have right now, but kindly seize only one thing, Lord. Is it not, Lord, something, Lord, astonishing that the tender committee will find out that gentleman, go to him and get a declaration from him after I submit the bid? Has they done it for all? Or I am the one? Whether this Swapon Kumar Das is a government employee or not, I cannot say right now. But kindly see, this is not there. Swapon writes to them, give a declaration on 6th of March. Who has got it? Lord, is the tender clauses allow them to make a roving inquiry, go and approach the persons individually, find out them whether they are employed or not employed, and had they have done it for all? If they have not done it for all, there is a pick and choose. Kindly take page 6. This prima facie shows that they pre-decided whom to be given, whom not to be given. Lord, department 42 articles. Lord, page 49. I am grateful to my learned senior friend that he produced it. If they had not produced it, I wouldn't have any case. Lord, 29 items tender floated. 29 items. They could find time only to find out the persons I have named.
That's
But
because
this is
you are
something
challenging.
shows. This is now something shows
All
that you
right,
are
we'll
predetermined.
consider the legal issue.
Lord, these are my submissions.
This intra-court appeal by the writ petitioner is directed against the order dated 4/4/2025 WPA 7082 of 2025, which was dismissed by the learned single bench. The said writ petition was filed by the appellant, praying for issuance of a writ of mandamus to quash the decision, rejecting the decision dated 23/2025, by which the appellant's tender was rejected on the ground, appellant's technical bid was rejected for the reason, inverted comma, due to improper technical manpower and insufficient machinery document, inverted comma, close. The learned single bench dismissed the writ petition on the ground that the appellant ought to have invoked the remedy available under clause 22.6 of the conditions of tender. '87. 22.6 of the conditions of tender, which states that evaluation of part 1 bids within bracket technical bid with respect to bid security, qualification, information and other information furnished in part 1 of the bid in pursuance to clause 12.1 of ITB, all capitals, shall be taken up and completed within 5 working days of the date of bid opening, and a list will be drawn up of the qualified bidders whose part 2 of the bids are eligible for opening. That's clause 22.5. Clause 22.6, which has been referred to by the learned single bench, states that the result of evaluation of part 1 of the bids shall be made public on e-procurement systems, following which there will be a period of 5 working days, during which any bidder may submit complaint which shall be considered for resolution before opening part 2 bid. As could be seen from the dates and events which have been the notice inviting letter was published on 6/1/2025. The date of technical bid evaluation uploading was fixed on 21/3/2025. The date of financial bid opening was on 28/3/2025, and date of uploading financial bid in the e-tender portal was 2/4/2025. And the date of acceptance, the letter of acceptance is 3/4/2025. Thus, the technical bid of the appellant was evaluated and uploading was made on 21/3/2025, which was a Friday. 22/3/2025 and 23/3/2025 were holidays on account of Saturday and Sunday. The date of financial bid opening was fixed only on 28/3/2025, and it was uploaded in the e-tender portal on 2/4/2025. Therefore, the appellant had sufficient time to invoke clause 22.6, and the respondent would be justified in contending that having not utilized that opportunity,
clause 47 misleading point, মিসলিডিং পয়েন্ট হলে ওই পয়েন্টই চলে যাবে।
advocate for the appellant, we need to take note of the scope of interference of this court in tenders, more particularly in tenders concerning infrastructural projects such as road construction and development. In this regard, we may refer to the decision of the Honorable Supreme Court in NG Projects Limited versus Vinod Kumar Jain, 2022 6 SCC 127. In the said case, the tender related to the road construction department of the Jharkhand, Department of Jharkhand. The Honorable Supreme Court took note of the decision in Silpi Construction Contractors. It is there in Contractors is Union of India, 2020-16 SCC 489, wherein the Honorable Supreme Court pointed out that the courts must realize their limitation and the havoc which needless interference in commercial matters could cause. Full stop. It was further pointed out that in contracts involving technical issues, the court should be even more reluctant because most of us, within bracket courts, most of us in judges' robes do not have necessary expertise to adjudicate upon technical issues beyond our domain. The relevant paragraph of the said judgment, namely paragraphs 19 and 20, have been quoted. In the said decision, the Honorable Supreme Court also took note of the decision in the case of UFLEX, UFLEX versus State of TN 2022 1 SCC 165, wherein the scope of judicial review has been discussed elaborately, and the limitations of such judicial review has also been pointed out. Further, the Honorable Supreme Court took note of the newly inserted clause HA, small a within bracket, in section 41 of the Specific Relief Act, 1963, which states that if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of relevant facility related thereto or services being subject matter of project. After taking note of section 41 HA, the Honorable Supreme Court pointed out that since the construction of road is an infrastructure project and keeping in view the intent of the legislature that infrastructure projects should not be stayed, the High Court would have been well advised to hold its hands to stay the construction of infrastructure project. Full stop. Such provision should be kept in view even by the writ court while exercising its jurisdiction Article 226 of the Constitution. In conclusion, in paragraph 26 of the judgment, it was pointed out, 26 of judgment, it was stated, a word of caution was mentioned that any contract of public service should not be interfered with lightly, and in any case, there should not be any interim order derailing the entire process of services meant for larger public good. Bearing the above decision in mind, we proceed to examine the contentions which were advanced before us by the learned advocate appearing for the appellant. Firstly, it is pointed out that while rejecting the petitioner appellant's technical bid, the decision was taken by a committee consisting of 13 persons, and the employer who issued the tender was only a special invitee who joined the meeting virtually, and this being contrary to the terms and conditions of tender. This contention has been rightly answered by the learned government council by referring to the memorandum issued by the Government of West Bengal Panchayats and Rural Development Department dated 29th July 2022, which was issued in compliance with the memo dated 14/9/2018 and supervision and supersession of all previous orders of the Department Tender Committee Engineering Works for PMGSY, RIDF and other engineering and related works executed from headquarters by department, and a committee consisting of 8 persons was constituted. The memorandum further states that the committee can co-opt any administrative or engineering officer depending upon the need of tender/bid as decided by the chairman from time to time. Thus, it can be seen that as early as 29 July 2024, for works concerning PMGSY, a tender committee has to consider the matter. It is not in dispute that the tender inviting authority or the employer was part of the committee. In any event, a committee is a larger body consisting of senior officials as mandated by the government in the memorandum dated 29 July 2022, and this cannot be a ground to contend that the entire evaluation process of the technical bid was flawed or defective or arbitrary. Therefore, such contention stands rejected. The next aspect is that the documents which were technical bid was rejected on the ground of improper technical manpower and insufficient machinery document. It is not in dispute that the appellant is existing contractor in respect of 3 other works in the very same district for which the work is in progress. According to the department, the requirement for providing adequate equipment has not been fulfilled by the appellant. It is needless to point out that if the appellant participates in a tender and the tender conditions stipulate is sufficient list of equipments to be provided, it goes without saying that those equipments should be exclusively used for the said contract, and therefore the respondents would be justified in coming to a conclusion that insufficient machinery document was one of the reasons for rejecting the technical bid. With regard to the manpower, the department has produced manpower. In the writ petition, it has been stated that one Tapan Kumar Das is shown to be an employee of the appellant company. However, the document appended to the tender schedule shows the credentials of one Sapan SWAPA Kumar Das. The said Sapan Kumar Das has given a certificate dated 3/6/2025 that his provisional pass certificate from a school in the year 2003 is being used by the appellant without his consent, which is an offense. And he has stated that he did not involve directly or indirectly with any type of work. And he does not know how his certificate was used. This prima facie shows that the criteria with regard to manpower does not satisfy. The clause 4.7 of the tender document deals with states that even though the bidders may meet the above qualifying criteria or not meet the qualifying criteria, remove the word above, they are subject to be disqualified if clause 1 I if they have made misleading or false representation in the forms, statements, affidavits, and attachments submitted in proof of qualification requirements. According to the evaluation committee, the stand taken by the appellant is found to be improper, and therefore they came to a conclusion that the technical bid cannot it does not does not qualify for consideration on account of improper technical manpower. As pointed out by the Honorable Supreme Court, this court does not have the requisite expertise to consider as to whether this as to the nature of the technical manpower that is required to be produced by a tenderer. Therefore, therefore, the approach of the court is to see whether there has been a reasonable approach taken by the authorities, and whether the decision-making process was just and reasonable. We find no grounds to doubt the justness or reasonableness of the tender of the process adopted by the authorities. Apart from that, the tender conditions also provide for a pre-bid meeting, and the learned government council appearing for the government council submitted that the appellant failed to attend the pre-bid meeting. Thus, for all the above reasons, we find that the appellant has not made out any case for interference with the decision taken by the authority to reject the technical bid of the appellant in the subject concerning the subject. For the above reasons, the writ petition, the appeal fails, and the same is dismissed. Sorry. I'll very heavy.
Good, my lord. If your lordship takes up item number 2, my lord, under extremely compelling circumstances, my lord, I'm mentioning a matter, my lord. My lord,
This is not.
my lord, tomorrow,
This procedure is unknown to
my
you.
lord, tomorrow, my lord, there is certain reasons. my lord. Tomorrow,
party application may be allowed on the previous matter.
Hello.
Application for addition of party, dispose of allowed.
Hello.
my lord, there is a reason, my
Under
lord.
the compelling circumstances, we have come up before your lordship. Lord, we want to have a Lord the Hanuman Chalisa part, because tomorrow is the Lord Hanuman Chalisa part in Red Road. Lord, tomorrow is the Hanuman Jayanti. So, my lord, we have the requisite permission from the army. Your lordship knows the land belongs to the army. So, we have the requisite permission. My lord, for the law and order situation, we sought permission from the local police. My lord, it was denied on the ground because of the traffic congestion. Your lordship, we want to perform it from 5 a.m. in the morning till 11 a.m. This is number one. And they are saying we are doing it for the first time, so it is not allowed. But the similar circumstances 7 days back on 31st of March, Lord, the one particular community, Lord, they have organized their program there, and Lord, the police was sufficiently adequately, Lord, given Lord the
What happened to your writ petition?
no, Lord, it has been my writ petition has been allowed, but no interim order has been passed. That is the reason, Lord, I want to move it for your lordship urgent basis, because tomorrow is the date.
Nothing doing. Hanuman will take care.
But kindly consider it.
I don't want to hear this. No more Hanuman Jayanti or no more Ram Navami. Nothing before me. If you want, we can release the matter. That's all. It's all you're making everything political. At the end of the day, genuine cases don't get decided, don't get heard. People are suffering, no pension, this, that, etc. 4 days, 5 days, central forces. You do whatever you want. You want leave to file, we will grant. That's all, maximum.
But if your lordship can place it in
I don't want to hear it. You file, leave.
any other bench, if your lordship can.
But we can't compel anybody, sir. How I can compel somebody say take it up today itself? Where are your papers?
Just now the order has been passed, my lord. Within half an hour we are going to file it. That is the reason I have come to take leave from your lordship.
I am not satisfied with the genuinity. Big people are appearing. I don't say no. The deputy solicitor generals are appearing in the matter, but I don't think so. We should get into this sort of.
But it's a legal issue involved. That is the
Nothing
reason.
at all.
Article 25 and 26.
Nothing at all. You give the memo, we right away dismiss it. What interim order? What has the learned judge said?
But the writ petition has been admitted, but the interim prayer for performing our program tomorrow, my lord, it has been.
And why did you come at the last
My
moment?
lord, we filed in long back, my lord. Last Monday we have filed it. Not this, my lord. The matter was pending,
And who
ultimate,
appears for the state?
my lord, AG was appearing, my lord.
And what was his contention?
My lord, his contention was that for the first time we are performing this, my lord, this program, so it should not be allowed. But your lordship at the same time,
But why you want to do it in the Red Road?
because the place is, my lord, it's
No,
not a
Red-
place of worship, my lord. That is the reason we want to do it there.
Pardon?
It is not a place of worship.
That is why
It's a public place.
that is where you should not do it.
And army has, my lord, allowed our application. They have given
Maybe-
permission, requisite permission.
That may be because the men behind them are powerful people. You have got that.
Well, it is nothing to do with politics.
Red Road is not for a purpose of this particular purpose.
I mean, the same place.
Normally, any religious festival will be done in a place where it is close to a mandir or somewhere which is.
But the entire Calcutta, your lordships knows, but there are lots of mosques are there. But this is the place where nearby there is no mosque or any other religious place is there. That is the reason we want to do it there. And Durga Puja Carnival also being held there.
My lord, Durga Puja Carnival is held there, my lord.
Carnival is, what are you going to do? You are going to perform puja. That is
only mantra of Hanuman Chalisa. That's it.
There will be a large
For 3 hours. For 3 hours.
5
Nothing more than that.
5 AM to 8 AM. My lord, it is the place, my lord, which has been used for that purpose for an innumerable number of years. Be it for any purpose, Red Road and that particular vicinity, there has been a history of 100 years, starting from 1946.
What happened last year?
My lord, since it had fallen from your lordship, my lord will not take us amiss, my lord. Since it has fallen from your lordships, that why that place? So, my lord, I was just trying with my humblest of request, my lord, that why that place? Because that place, if my lord will see, Esplanade East is a place where all political rallies are held. Because it has a particular position or which has been reckoned for years together, just in front of Tipu Sultan Mosque. Well, I am a resident of that vicinity. My grandfather used to say that whatever happens in West Bengal, everybody comes in front of my house. Why? But that space, that particular area, Red Road and that particular vicinity is a particular place where I am not on any community or any particular thing. Even for March past, lordship will kindly see 26th of January, Red Road is used, and that was even for rallies, my lord has heard so many petitions that rallies are being held. My lord, I'm great.
Bring the paper, let us see. You serve notice.
Yes. At 2, my lord, should I come at 2? We'll file it right now.
Bring it now itself.
Lordship. We shall inform the Advocate General also.
I'm indebted to my lord. I apologize, my lord. Just, my lord.
You're indebted for leave to grant. You please get the paper.
Yes, yes.
You inform the Advocate General.
Yes.
This intervening
Original side list to be mentioned, item number 1.
I beg to appear for the appellant in both the matter, my lord. Lordship, kindly recall, my lord.
No. My lord, I am appearing for CBI.
why it is coming?
My lord, I'll tell your lordship why, my lord. My lord, on 7th of, my lord, we had, my lord, mentioned the matter. My lord, on 7th, my lord, of February, my lord, your lordships, my lord, had granted a stay, my lord, of the order, and thereafter, my lord, your lordship had also, my lord, directed.
We extended it till 23rd April.
Correct. My lord, it's not, my lord, now, my lord, after that, there was a 5th March order, my lord, where, my lord, time was given, and, my lord, lordship will find, my lord, that affidavits, my lord, were to be completed in the intervention. That has happened, my lord. Then your lordship, my lord, had indicated, my lord, that a date would be fixed because there's no date. So, my lord, kindly, my lord, my request is subject to your lordship's approval. Could it be sometime in May, my lord? I'm in some difficulty, my lord.
Any day,
towards-
my
My lord, we have no
As per
difficulty,
convenience
my
of
lord.
the learned friend or
Only
any
as as your lordship has been pleased to direct us, my lord, to file the affidavits. My lord, affidavits are exchanged.
Your application has been allowed for.
No, no, no,
No,
no,
no,
no.
that
That's
is
the,
intervening is pending.
That is fine.
Mr. Mukherjee, the learned senior advocates, my lord, his client filed a opposition.
Opposite.
We will be filing
my
the,
lord, that's our opposition, my lord. We wanted to
may
file.
we file the reply, my lord, we have served. My advocate on record has served. Your lordship kindly fix a date.
Affidavit in opposition to the application filed by CBI for intervention has been filed, which is taken on record. And CBI has also filed a reply.
Yes, my lord, it's,
Which is also taken on record.
My lord.
On what date we'll fix it, sir?
my lord, any date in May, my lord. My lord,
You just please ensure that there is no Ram Navami or.
my lord, that's why I ran away. My lord, I ran away, my lord, because my lord, I can't, my lord, it's not possible, my lord.
I
For me.
think sir can recollect what happened 2 years back.
Yes,
2 days, 3 days, 4 days.
my lord, I was before your lordship, my lord.
That's true.
Nothing, we could do nothing.
That's true.
My lord, I was before.
And two big, two seniors are appearing.
My lord, only one thing I also wanted to indicate, my lord, your lordship's order, my lord, of 7th February, my lord, one of the issues was, does a complaint survive at all when an FIR has been filed, my lord? My lord, we'll also be challenging, my lord, I have advised. I hope it's accepted. My lord, challenge, my lord, the FIR itself, my lord, by way of a separate proceeding. Just wanted to indicate that.
My
also.
interim order may be extended, my lord.
Yes, that was till 23rd, my lord, your lord.
It was till 23rd April.
Yes, Lord.
We'll have it in June, 13th,
My lord, I have no problem.
13th June.
After, I guess.
List the matter on 13th June.
No,
The interim order already granted shall stand extended till 27th June.
Very well. My lord, one indulgence, my lord, I can pray for, as because your lordship is hearing the matter, my lord, for a long period, my lord, can it be part heard? My
No,
lord,
no.
my lord, otherwise your lordship, my lord.
No, no, it will come. Oh,
Very well.
remove.
My lord, kindly, if your lordships kindly give a date, my lord, in June.
না, না, ওটা তখন বলবো।
13 June, I'm grateful.
Deeply obliged.
And my lord,
And your
and I'm
lordship,
hoping, my lord.
that readings are complete. So for intervening application.
Yes, my lord, that's
Next.
Grateful. one.
and my lord, I'm hoping my advice is followed, my lord, with
Right.
my lord challenging the FIR.
Grateful.
Item number 3.
Milord, 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 in that respect, Milord, I beg to mention one thing that this final order of the learned tribunal has been rectified by the miscellaneous order, which was passed on 20th February, Milord. That was received on 90th March. So delay, if that is calculated, would be
There won't be a delay. Technically, there won't be a
no,
delay.
there would be delay of 180 days, Milord. That has been reflected in our application, Milord. The para 2, page 3 of our application of delay. Condonation of delay. GA1. Yes, yes.
No, it is a remand order.
Milord,
It's an order of remand.
Milord.
And why have you challenged the order of remand? Because the tribunal says the appellant is required to give invoice-wise details of deductions made by the client to prove that these amounts were not received by the appellant so as to get exemption from service tax payment. They are also required to show the details of the client's ledger towards the value of the invoice amount so and so. All these details are required to be produced in respect of invoices so and so. Therefore, we remand even this matter to the adjudicating authority. Would follow the principles of natural justice, allow appellant to file. On what ground you are now?
My lord, there are two parts in it. This is the part mining services which they have remanded. There are two others that before the mining starts, overburden clearance is done, and transportation from the mines to the railhead. Now that was prior to 1/6/2007. So the question that arose is whether they are to be covered by the specific headings or they are mining services. If they are mining services,
In fact, we decided earlier.
Your Lordship will decide in Atwal's case. Your Lordship will decide in this matter.
Another matter also, we said it's a composite service.
Composite service, yes. Whenever it is
composite contract.
Well, this Larsen and Toubro decides this, and Your Lordship has followed an Indian Shipowners Association. Your Lordship has followed those decisions.
And where is the finding with regard to that?
Yes, madam, that is.
We know, para 2, page 24.
Yes, ma'am.
We notice that the documentary evidence placed before us, appellant has provided mining services as a composite service. Manasi, we decided similar issue
My lord.
last week also.
In addition also, my lord, they have availed the abatement of pure agent charges, which has not been reflected in their separately in their bill. My lord, their service tax return has contradicted with the income tax.
No, there are two issues. One is mining services, another is site formation. You have proposed
That is the next matter, my lord. This matter relates to cargo, my lord.
On the same ground, we set aside the confirmed demand.
Yes.
No, adjudicating authority has already dropped the proposed demand on site formation.
Yes.
And on appeal, we have dismissed the revenues appeal. On the same ground, we set aside the confirmed demand for cargo handling.
On the same ground.
And where is that order of the tribunal dismissing the revenues appeal against, with regard to site formation service?
Order of the tribunal, my lord. Well,
Which-
the next matter, my lord. The 9.
Already, we'll condone the delay, sir.
My lord, my lord.
Yes, madam.
Delay
Let it be
can
hard,
condoned,
Lord.
so that she'll get ready with the matter.
Lord.
You are aware of the decision we have taken
My lord,
earlier?
my lord.
Huh? Okay.
While I was drafting it, it was pending, my lord.
We have heard so and so. There's a delay of so and so days. As the explanation offered is found to be satisfactory, and sufficient cause has been shown for not preferring the appeal within the period of limitation. The delay in filing the appeal is condoned application.
My lord, the affidavit of service, my lord, be kept.
Affidavit of service kept on record.
Let us fix the matter on the date.
Probably it can't come next Friday.
No.
Probably the week after.
Deeply.
Whatever it is.
Well, week after, my lord is keeping me deeply obliged. My lord, both the matters, my lord, 3 and 4.
Yes.
Deeply. 4, my lord. 4, my lord. Some of 5.
But I'm appearing. File my service. It's the intercourt appeal. There's delay of 235 days in filing the appeal.
I am appearing on behalf of the respondent, my lord. I want to oppose the delay.
And the
Already, you file your affidavit in opposition. You grant some 3 weeks time.
I'm good.
Next.
Number 6. Please, madam. I'm appealing for the respondent revenue.
Yes.
The main question is false for your lordship consideration that which will be the date of transfer in respect of the property, that is the one rice mill we have purchased in the backward area in the Purulia, my lord. Here, my lord, that I am coming to the facts first, my lord. In the year 2016, that is 30th December 2016, my lord, we have purchased we have entered in the agreement for sale for the purpose of purchase of this rice mill, my lord. And at the time of agreement, entire sale consideration of rupees 86 lakhs we have paid, and it has been paid through the banking channel. I have enclosed the respective documents also, my lord. And upon payment, my lord, on that day, they have relinquished all their rights. They have given me the positions, and we have started the functioning of the rice mill. We have started the productions, and the profit we have earned, we have already disclosed in the respective assessment year. That is the 17-18, my lord. And it is on the part of the document also, my lord. We have enclosed it. And subsequently, my lord, for the assessment year 2007, and another important fact is that for that period, the department done the 147 also. And during the 147, the scrutiny has been made, and the bank statement was before the assessing officer. From here, we can show that that amount I have paid for the purchase of this agreement. Sorry, for requirement of this purpose of purchasing of this rice mill. And not only that, that we have disclosed the turnover of the rice mill also in the books of accounts. It was before that. But they have not taken any adverse things in the assessment order. But subsequently, for the assessment year 2018-19, for the purpose of 56(2) subsection clause 10, which says about the income from the other sources, for this purpose, they have taken the value, that property value, that circle value of the property, which is exceeds the market value of the property for the purpose of the income tax purpose. Our contention is, my lord, the transfer already made as per the section 247, subclause 2 and 6, which clearly says that they are about the de facto transfer. De facto transfer means, my lord, if there is any possession, handover of the possession, effective control already transferred, the transfer will be taken as a transfer even on the date of agreement for sale, even the register has been made on the subsequent date. In our case, the registration has been made in the year of assessment year 18-19, but agreement for sale already made in the 17-18, assessment year 17-18. That is why our contention is for the purpose of section 56(2)(10, for the purpose of the computation of the income and income from other sources, the transfer should be taken for the year 2017-18, not 18-19. This is only for the consideration, my lord. And this contention already covered by the judgment of the Supreme Court, that is Sanjeev Lal. Lordship, kindly allow me to place the judgment. After that, I will again come to the facts as it is fitting with the case or not. Lordship, kindly allow me. Judgment. I have prepared one short list of dates, my lord, and judgment. Lordship, kindly take. If required, I will read the facts of the case, but before that, Lordship, kindly take the Placidum 20. The question, may I read, my page 398, Placidum 20.
398. The question to be considered by this court is whether the agreement to sell which has been executed on December 27, 2022 can be considered as a date on which the property, that is the residential house, has been transferred. In normal circumstances, by executing an agreement to sell in respect of an immovable property, a right in Pashanama is created in the favor of the transferee or vendor. When such a right is created in favor of the vendor is the restraint from the selling of the said property to someone else because of the vendor in whose favor the right is in Pashanama is created has a legitimate right to enforce the specific performance of the agreement. If the vendor for some reasons is not executing the sale deed, thus by the virtue of agreement to sell, some right is given by the vendor to the vendee. The question is whether the entire property can be said to have been sold at the time when the agreement for sale is entered into. In normal circumstances, the apostated question has to be answered in the negative. However, looking to the provision of Section 247 of the Act, which defines the word transfer in relation to the capital asset, one can say that if a right in the property is extinguished by the execution of an agreement to sell, the capital assets can be deemed to have been transferred. Relevant portion of the Section 247 defines the word transfer is as under. Section 247 transfer in relation to the capital assets includes the extinguishment of any rights therein or. Now, in the light of the definition of the transfers defined under Section 247 of the Act, it is clear that when any right in respect of any capital assets is extinguished and the right is transferred to someone, it would amount to transfer of a capital assets. In the light of the opposite definition, let us look the facts of the present case, where the agreement to the sale of the respect of the capital asset has been executed on December 27, 2022 for transferring the residential house, original asset in question, and a sum of rupees 50 lakhs had been received by way of earnest money. It also not in dispute that the sale deed could not be executed because the pendency of the litigations between the Sri Ranjit Lal on the one hand and the appellants on the other, Sri So and So, challenge the validity of the will under which the property has developed upon the appellants. The virtue of the order passed in the suit filed by the Sri Ranjit Lal, the appellants were restrained from the dealing with the said residential house, and the law-abiding citizen cannot be expected to violate the different directions of the court by executing a sale deed in favor of the third party, while being the restrained from the doing so. In the circumstances for a justifiable reason, which was not within the control of the appellant, they could not execute the sale deed, and the sale deed has been registered only on September 24, 2024. And after the suit filed by the Sri Ranjit Lal, challenging the validity of the will had been dismissed. In the light of the opposite fact and in view of the definition of term transfer, one can come to the conclusion that some right in respect of the capital assets in question has been transferred in favor of the vendor, and therefore some rights which the appellants had in respect of the capital assets in question had been extinguished because after execution of the agreement to sell, was not open to the appellants to sell the property to the someone else of the accordance with the law. A right of Pashanam had been created in favor of the vendee and whose favor the agreement to sell had been executed and who had also paid 50 lakhs by of earnest money. No doubt, such contractual right can be surrendered or neutralized by the parties through the subsequent contract or conduct leading to no transfer of the property to the proposed vendee, but that is not the case at hand. In addition to the fact that the term transfer has been defined under Section 247 of the Act, even if look at the provision of Section 54 of the Act, which gives relief to a person who has transferred his own residential house and is purchasing another residential house either before 1 year or the transfer even 2 years after the transfer, the intention of the legislature is to give him relief the matter payment of the tax on the long-term capital gain. It is not a very relevant now. Now, the next, my lord. In Placidum 23, next page. The consequence of the execution of the agreement to sale are also very clear, and they are to the effect that the appellants could not have sold the property to someone else. In practical life, there are the events when a person, even after executing the agreement to sell an immovable property in favor of the one person, tries to sell the property to another. In our opinion, such an act would not be in accordance with law, because once the agreement to sell is executed in favor of the one person, the said person gets a right to get the property transferred in his favor by filing a suit for the specific performance. Therefore, without hesitation, we can say that some rights in respect of the said property belonging to the appellant had been extinguished, and some right has been created in favor of the vendor or transferee when the agreement to sell has been executed. Thus, the right in respect of the capital sale property in question had been transferred by the appellant in favor of the vendee on December 27, 2022. The sale deed could not be executed for the reasons that appellant had been prevented from the dealing with the residential house by an order of the competent court, which they could not have violated. In view of the apostated particular facts, the case has looking at the definition of the transfers as defined in 247 of the Act. We are of the view that the appellants were entitled to relief under Section 54 of the Act in respect of long-term capital, in which they had earned in the pursuit of the transfer.
247 is clear.
Yes, my lord. This is my case, my lord.
Extinguishment.
Extinguishment in that case, my lord. I have paid the entire amount through the banking channel. I will show from the document. I have taken
Mr. Mitro,
yes, my lord.
The order of the tribunal is wrong.
Yes, my lord.
No, I shall indicate, my lord, the provisions, my lord, by virtue of which, my lord, the transfer has been defined in the Income Tax Act, my lord, is very specific.
Transfer as defined under the Transfer of Property Act, and that definition into the Income Tax Act is quite different.
Yes,
yes.
Now, last week, I think last week or 10 days back, we decided one matter. You are not carrying any Calcutta High Court judgment.
No, I am carrying the Supreme Court, all Supreme Court.
Because
the
transfer in relation to a capital asset includes sale, exchange or relinquishment of the asset, or the extinguishment of any rights therein. Yes, then the clause 3 will not be applicable. It's not a compulsory acquisition. Floor also won't be applicable, stock in trade. Then 4A also not applicable. Part performance 53A is not their case.
Yes.
6. Any transaction, whether by way of becoming a member of the acquiring shares, so which has the effect of transferring the enjoyment of immovable property.
Yes.
So
my submission is that this is also not applicable, because my lord, this is only with regard to the cooperative societies.
Correct.
My lord, the case in hand, my lord, that has been, my lord, placed by the SSC before the tribunal, my lord. The tribunal had, my lord, got the occasion, my lord, to distinguish that case with regard to the fact that that was on cooperative societies. Now, my lord,
clause 2 will be applicable. See, on the date of agreement for sale, he has paid the entire sale consideration.
Yes.
A right has accrued in favor of the purchaser.
Now, I shall, my lord, indicate to your lordship, my lord, factually, my lord, this contention was not made before, my lord, either before the assessing officer or before the tribunal. If
Mr. Mitro, on the second issue, they agreed with the SSC with regard to circle rate.
Yes, that is something, my lord.
Both the findings are contrary.
And not only that, we have taken all the facts before the tribunal. That point we have taken in the tribunal, my lord, with the documents, my lord. That our written notes of argument before the tribunal was shared with my lord. My lord.
I shall indicate to your lordship, my lord, that even, my lord, this agreement for sale, my lord, that is, my lord, as per the contention of my learned friend, was, my lord, taken place in the earlier assessment year. That was not brought to the
always individual assessees will lose before the tribunal.
No, but this agreement for sale, my lord, was not brought to the notice of the assessing officer. Now, my lord, when, my lord, this...
No, tribunal. We are only testing the correctness of the order of the tribunal. the tribunal has extracted the agreement, clauses in the agreement, and the only reasoning they say, deed of transfer not executed. But you
Yes,
have
my
to
lord.
view it from the angle of 247, definition of transfer under the Income Tax Act.
I'm grateful, my lord. Section
All
247,
right.
my lord.
What is the
my
other
lord.
judgment you are having?
Order, my lord.
Other judgment you said?
Yes, my lord. Always sing, my lord. That it is a Supreme Court judgment also.
My lord, section 247, my lord, specifically say, my lord, it has to be sale. Now, my lord, sale, the definition of which, my lord,
No,
has to
no,
be,
no.
my lord.
What is all this? You please see the definition 247. It says extinguishment of any rights therein. Put in possession, entitled to operate, full sale consideration place. What more do you want? And the learned tribunal says you treat this transaction for 1718 and apply that circle rate because the entire sale consideration paid during the said assessment year.
But that was
Then
not the
that
case, my
it is deemed that it is a valid transfer.
But that
And
was not the case.
No, no.
My lord, that
The
was not the
vendor
case of the
cannot
FSC.
leave the
My lord, even
property.
my lord, if I, my lord, most, my lord, may indicate, my lord, even my lord, the agreement for sale,
Page
my lord, that has
549,
been
my lord.
produced,
549.
it
Placidum
says that, my lord,
21.
the entire consideration has not been paid.
Supreme Court interpret to 240 and another different angle, man. Under section, last paragraph, Placidum 21. Under section 247(6), any transaction which has the effect of the transferring and enabling the enjoyment of the immovable property would come within the this purview. What more, my lord? And High Court has not adverted to the expressions to any other manner whatsoever. And in subclause 6, which would show that it is not necessary that the transactions refer to the membership of the cooperative society. We have therefore to see whether the impugned transaction can fall within this provision. And the object of section 247(6) appeared to be to bring within the tax net a de facto transfer of any immovable property. It is called de facto transfer. The expression enabling the enjoyment of the text color.
One second. Mr. Mitro, in fact, if the order of the tribunal is allowed to stand, it will affect the department in some other matters. Because normally the department says, by using the definition under 247 clause 2, they will assess them in the year, the date of transfer will be construed to be the date on which the party is put in possession of the property and the sale consideration is. Whereas the assessee will contend, no, this has to be assessed on the date on which the sale deed was executed. So there the revenue stand will be, no, you should take the previous assessment year when the transfer took place. So
No,
this will actually affect you.
But if I could, my lord, only point out, my lord, the tribunal, my lord, had actually addressed that part as well. If your lordship, my lord, kindly turn to, my lord, internal page 7 of the impugned order in question, wherein, my lord, these issues has been addressed.
But then the issues with regard to how 247 is to be interpreted.
And Supreme Court also says in which
Otherwise, my lord, it will, my lord, leave, my
the
lord,
income
no
or any
distinction between, my lord, agreement
that year
person and
and
sale deed.
Whatever this expenditure which he has incurred was assessed in 1780.
Yes.
147 reopened and affirmed in 1718.
Because of the fact, my lord, at the relevant year when, my lord, this agreement for sale was executed, my lord, the assessee, my lord, did
You are
not
not
brought that
bringing Calcutta High
information
Court,
to the
sir,
assessing
because you are
officer.
not, but you are practicing in Calcutta High Court, not giving in Calcutta High Court. This appeal filed under section 260 capital A of the Income Tax Act 1961 within bracket the Act by the assessee is directed against the order dated November 20, 2024 passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket Tribunal in ITA number 1797/KOL/2024 for the assessment year 2018-19. The assessee has raised the following substantial questions of law for consideration. Page.
At page in memorandum of appeal, my lord.
Page 18.
It is 8.
Question A, B, C, D. That's all. We have heard Mr. Somak Basu and Mr. Tilak Mitra. The short issue which falls for consideration is whether the assessee was right in contending that they purchased the asset in question, namely a rice mill, should be taken to be on the date when they entered into the agreement for sale of the property, which was made on 30/12/2016, or when the registered sale deed was executed and registered on 21/3/2018. The facts which are not in dispute are that the assessee entered into an agreement of sale with the vendor for sale of a rice mill situated in the district Purulia. The relevant terms and conditions of the agreement for sale has been noted by the tribunal and extracted in the impugned order, from which it is seen that the assessee, who was described as the second party in the agreement for sale, was required to pay a total sale consideration of rupees 86 lakhs as full and final payment for sale of the rice mill, along with the factory, plant and machinery, and that the assessee was required to pay the said amount within 30th December 2016. Upon such payment, the vendor was bound to execute the sale deed within 2 years of receipt of the entire sale consideration, full stop. Further, the agreement states that the vendor, on receipt of the amount of rupees 86 lakhs, will immediately deliver possession of the factory premises to the assessee, and the assessee shall have a right to take electricity connection, trade license, government permit and all other licenses to run the rice mill, and the vendor will not give any objection to the assessee before any authority of law or government office. Further, the agreement states that on payment of rupees 86 lakhs on 30/12/2016, the assessee shall have a right to run the business in the factory premises. The tribunal does not dispute the fact that the entire sale consideration was paid by the assessee on the date when the agreement for sale was executed, and that the assessee was put in possession of the rice mill along with the plant and machinery, and they were also commenced production in the rice mill. If such is the nature of the transaction, what is required to be seen is whether this will qualify to be construed as transfer as defined under section 2 within bracket 47 of the Act. The Honorable Supreme Court in Sanjeev Lal versus CIT 2014 365 ITR 389 considered this issue, and it was held that and the question which fell for consideration before the Honorable Supreme Court was whether the entire property can be said to have entire property within bracket therein can be bracket close can be said to have been sold at the time when an agreement to sell is entered. The Honorable Supreme Court pointed out that in normal circumstances, the aforestated question has to be answered in the negative. However, looking at the provisions of section 2 within bracket 47 of the Act, which defines the word transfer in relation to a capital asset, one can say that if a right in the property is extinguished by execution of an agreement to sell, the capital asset can be deemed to have been transferred. After noting the definition of transfer as defined under section 2 within bracket 47, and in particular clause 2 two eyes. It was pointed out that in the light of the definition of transfer as defined under section 2 within bracket 47 of the Act, it is clear that when a right in respect of any capital asset is extinguished and that right is transferred to someone, it would amount to transfer of capital asset. The court examined the facts of the said case and found that pursuant to the conditions contained in the agreement for sale, the vendee in the said case, the vendee in the said case had acquired a right in favor in respect of the property in question, and the right of the vendor therein stood extinguished because of the execution of the agreement for sale. Therefore, what is required to be taken note of is that that a purposive interpretation of the provisions of the Act should be given while considering a claim for exemption from tax. And that apart, there should be a harmonious construction of the provisions which subserve the object and purpose should also be made while construing any provision of the Act, more particularly when one is concerned with exemption from payment of tax. More or less, a similar view was taken by the Honorable Supreme Court in Commission of Income Tax versus Balbir Singh Maini, M-A-I-N-I, 2017 398 ITR 531 within bracket SC. In the said case, the Honorable Supreme Court took note of the various clauses in section 2 within bracket 47 of the Act. And what was relevant in the said case was clause 6 within bracket 6I, small 6, VI, V1. And the Honorable Supreme Court did not agree with the view taken by the High Court and held that under section 2 within bracket 47 within bracket Roman 6, any transaction which has the effect of transferring or enabling the enjoyment of any immovable property would come within its purview. Therefore, the legal issue is well settled, and the view taken by the tribunal that by execution of the agreement of sale, no right accrues in favor of the assessee does not lay down the correct legal principle. That apart, the income, the sale transaction was assessed to tax in the assessment year 2017-18, and the said assessment was subject matter of reopening under section 147 of the Act, and the reassessment was completed. In fact, the learned tribunal, while considering the second issue as to the applicable circle rate of the property, has held in favor of the assessee by taking note of the fact that the entire sale consideration has been paid at the time of execution of the agreement of sale, and therefore the stamp duty or the stamp duty value / circle rate has to be made up, circle rate as applicable on 30th December 2016 has to be applied in the assessee's case. Therefore, we are of the view that therefore this finding on the second issue is contrary to the finding rendered by the tribunal on the on the first issue, which is a preliminary issue. Thus, we are of the view that the learned tribunal committed an error in coming to the conclusion that the transfer did not take place in favor of the assessee on and from the date of execution of the agreement of sale, pursuant to which the entire sale consideration was paid and the assessee was put in possession of the property which was purchased by them. For the above reasons, the appeal is allowed. The order passed by the learned tribunal is set aside and the substantial questions of law are answered in favor of the assessee. Thank you. Next.
My lord, item number 7 to 9, I am led by Mr. Jishnu Shah and my lord, Mr. Anirban Ray. My lord, my learned leaders are on legs. My lord, I am praying for a Passover, my lord.
Passover could you know, may not today. तो Passover ने मैंने फिर मैं फिर बुधवार को नहीं रहूंगा लेकिन
It is against a common order, is it?
My lord, the main order is in item number 9, my lord.
Item number 9, if my lord can
APOT
take
91, my lord.
All right, Passover.
Obliged.
my lord. इसके बाद वाला भी तो 7 to 9.
My lords, I am appearing on behalf of the respondents.
My lord, for your lordship's convenience, my lord, we have prepared a short list of dates because there are many events which are over the other side. My lord, first issue is
we have prepared a compilation of relevant provisions and case laws.
Well, the issue before the tribunal, which has adjudicated, is with regard to the refund of 6.93 crores, which have been granted. Now, the interest which has been awarded by way of calculation is around 10.52 crores. Well, kindly see the list of dates and 2 annexures we will be referring.
You said dates.
Yes.
So it is only the interest claim.
Yes, Malad. Malad, it is coming to around 10 crores.
Maybe 100 crores also. But what is your defense?
Yes, Malad. Malad, kindly come to section 27.
It is there in this compilation,
Yes.
page 4.
Well, the prerequisite of qualifying for refund of duty is that there must be an application in the form and manner as may be prescribed. Second, my lord, your lordship will kindly turn to subsection 2. If on receipt of any such application, the Assistant Commissioner of Customs or Deputy Commissioner is satisfied, then your lordship will kindly come to subsection 3. Notwithstanding anything to the contrary contained in any judgment, degree, order or direction of the appellate tribunal, national and any court or any other law or any other provisions of this act or the regulations made thereunder or any other law for the time in force, no refund, that is very important, no refund shall be made except as provided in subsection 2. Now the subsection 2 provides that there must be an application for refund. Now over here, the application for refund was formally filed by the petition on 5/8/2020.
No, that is, that can't be reopened now.
No, Malad.
The assessing officer ultimately
allowed
and
the refund. Now with regard to the interest, we are before your lordship.
only on the interest.
Yes.
So you can't argue it is
No,
not
no,
in
no,
the
no.
subsection.
Whatever is admitted, my lord, what will be our argument before your lordship? What will be the effective date from which he is entitled to interest? The tribunal, the tribunal over here referred to one remand order of the commissioner appeal by saying that order, that remand order will be construed to be the date by which the interest is liable to be paid. Because over here, the petitioner over here has made voluntary declaration. Kindly come to page 34 of the first compilation, stay application. Well, that will give some light what was the main defect which the petitioner has done and what was he demanding. Well, it is serial number. Number? Well, serial number 6 was construed to be the date by which the tribunal has held that serial number 6 date is the date by which he is entitled to interest from that day. At that point of time, my argument will be before your lordship, the amount has not crystallized. When there is no amount which has been refunded or there is no appropriate order which has directed the refund, then only the payment of interest will arise. Therefore, my lord, first annexure, what was the nature of the defect which was occurred in the... Well, the order is very much voluminous and...
Where is the order of the tribunal? Page 154.
Internal for 36.
Correct?
Yes.
1-5.
Well, before that, only page 32, my lord, for once. Thereafter, your lordship reads the tribunal's order. What is the nature of the defect which has happened in the petitioner's application? Page 32, stay application, first volume.
Yes.
Only, my lord, only page 32. Thereafter, your lordship kindly read.
32,
No,
34.
Well, sorry, 34, sorry. 34. Annexure B. This is the reply of the customs application under section 154 of the Customs Act 1962. Please refer to your letter dated so-and-so on the above subject and subsequent letter so-and-so forwarding the copies of the shipping bills and the customs signed invoices in the matter. On verification of the related documents, it is seen that the shipping bills in questions were assessed based on the declaration of the exporter with regard to the description of goods, percentage of the PE content, quantity, and the related documents submitted at the time of assessment, including the invoices, pre-shipment, inspection certificate, etc. It is seen that there is no mistake, clerical or arithmetical on the part of the assessing officer in the assessment of the shipping bills. Therefore, it is not a case covered under section 154 of the Customs Act 1962, which is confined to clerical or arithmetic mistakes in a decision or to errors therein from an accidental slip or omission. Now, in the shipping bills, it is their voluntary disclosure made by the petitioner that it is 300 per metric ton, which will be the assessable duty. Now, to that extent, these litigations went from time to time, up and down, and ultimately, it was and ultimately by serial number
5/9 to 18.
18, my lord. On 5/9/2023, as per the order of the Honorable Court and also the order of the tribunal, the amount of refund, which was 6.93 crores, was given back to the petitioner. And immediately on the next day, the same amount was credited in the account of the petitioner. Thereafter, my lord, he filed an independent application before the authorities concerned, which went up from the adjudicating authority to the appellate authority and then to the tribunal, which culminated in the tribunal holding that interest beyond the statutory period, that is 12% when it is 6 or 5% variable, is to be paid, and it is to be retrospective from the date of 11 January 2011 to the date when the tribunal passed an order, till the date when the refund was sanctioned.
Interest কখন দেবে provision 27?
Now, I will be further referring, my lord, section 27A, which has also not been considered by the learned tribunal. If any duty ordered to be refunded, the word is refunded and the duty ordered to be refunded. So the order of refund has crystallized
5/9/2020.
on 5/9/2023. To an applicant is not refunded within 3 months from the date of receipt of the application under so and so, there shall be paid to an applicant interest at such rate not below 5%, not exceeding so and so, as in time being fixed by the central government by notification in the official gazette on such duty from the date immediately after the expiry of 3 months from the date of receipt of such application till the date of refund. Yes. Well, these are my legal grounds before your lordship with regard to the order of the learned tribunal and the learned tribunal. Go to page
35. 38 টাকে দেখান, এই যেটা রিমান্ড করলো ট্রাইব্যুনাল রেজ দ্য ডিউটি অর্ডার ফর রেক্টিফিকেশন, এটা দেখান পেজ 38.
Lordship, if I may submit.
No, wait. He's yet to finish.
Okay.
Well, it will take some time. 115 to 2. 115 to 2. Continue. Well, today itself or? Today itself. Yes. But unnecessarily you drag the matters. Well, that way. Now we are 14 years. Yes, ma'am. And in between there were orders. The revenue was not on appeal. There was a direction. Date was fixed. So ultimately the tribunal had to do an exercise to find out from the date on which interest is paid.
Satisfied.
Anyway, let us see. Lodge. What happened to your matter?
Yes, fine.
Where is it? You get the paper. And who will appear for the state? You will be appear. No copy has been given.
We'll give, right?
Give. Second half we will take. What to do? It is running, not running. They have mentioned we have granted leave. They say the function is tomorrow. The learned single bench has now admitted the writ petition, no interim order. Similar prayer we have entertained at the instance of the learned advocate general. If it is inconvenient from him, AG can appear, you can appear, madam can appear.